Today we are going to be looking at the control of restrictive agreements in the European Union. As we have seen, one of the most significant EU competition law prohibitions is set out in Article 101(1) of the Treaty on the Functioning of the European Union, prohibiting restrictive agreements and concerted practices between undertakings. For an agreement between undertakings to be considered void, three conditions must be met. First, there must be an agreement or concerted practice between two or more undertakings to restrict competition. Secondly, the agreement or concerted behaviour must have as its object or effect the distortion of competition within the common market. And thirdly, the agreement or concerted behaviour must have an effect on trade between member states. Let's look at each of these three conditions in turn. First requirement is that an agreement or concerted practice between undertakings exist. Thus, the first question is, what is an undertaking? The notion of undertaking is defined very broadly in EU competition law, and it refers to any kind of economic operator, no matter its legal form, once it is engaged in an economic activity. Thus, an undertaking can be a profit or non-profit driven organisation. It can be a private individual engaged in a business, a small private company, a large multinational, or even an association representing a particular industry. What then is a concerted practice? Pursuant to Article 101(1), not only are anti-competitive agreements between undertakings prohibited, so too are concerted practices between undertakings. The notion of a concerted practice is interpreted broadly. In the opinion of the Court, a concerted practice is deemed to arise where there is coordination of the parties' behaviour, leading them to substitute cooperation between them in place of the risks of competition. The second requirement of Article 101(1) is that the agreement have as its object or effect the distortion of competition. Once it is established that there is an agreement or a concerted practice between two undertakings, the second requirement in order to trigger the Article 101 prohibition is that the agreement have for its object or effect the prevention, restriction, or distortion of competition. Thus, even if the parties do not intend to restrict competition, once their agreement has an actual anti-competitive effect, it will be considered to come within the scope of the prohibition. The final requirement of Article 101(1) is that there be an effect on trade between member states. This final requirement for behaviour to come within the Article 101 prohibition requires that the agreement have an effect on trade between member states. If there is no effect on trade between member states, then the jurisdiction of the EU authorities is not triggered, and the matter may instead come within the jurisdiction of the competition authorities of the appropriate member state. However, the Commission has given a dynamic interpretation to the notion of an effect on trade between member states. Once an agreement meets these three conditions set out above, it is considered to restrict EU competition law and normally will be automatically void under Article 101(2). Now, let's take a look at vertical and horizontal restrictive agreements. It should be recalled that EU competition law is applied not just in the context of a strict economic analysis of consumer welfare, but also, more fundamentally, in the context of the aims of the Union itself. Thus, even where an agreement has limited anti-competitive effect from the point of view of consumer welfare, it may nonetheless be considered as being contrary to EU law where the agreement undermines the basic aims of the Union. In this regard, it is interesting to consider that agreements entered into between undertakings may be broken into two basic categories: horizontal agreements and vertical agreements. Horizontal agreements are agreements between undertakings operating at the same market level. A classic form of anti-competitive horizontal agreement is a cartel, whereby a group of competing market players together agree to act in an anti-competitive manner. For example, if the manufacturer of mobile telephones in the EU come together and decide to charge the same or similar prices for their products. Such agreements are considered to be particularly anti-competitive as they suppress inter-product or brand competition. Inter-brand competition occurs where there is competition between different brands of similar products, for example, between the different mobile telephone brands. The second category of agreement is vertical agreements, and these are agreements that are entered into between market participants operating at different levels of the market. For example, an agreement between a mobile phone manufacturer and its distributor whereby the distributor is given exclusivity for the distribution of the manufacturer's telephones for a particular geographic area. In principle, such an agreement is anti-competitive because it prevents other distributors from distributing the manufacturer's products in that territory, and thus necessarily restricts competition. However, the restriction on competition is not as important as in the case of a horizontal agreement, as the agreement does not suppress inter-brand competition, but intra-brand competition, i.e., competition in the brand of the mobile telephone covered by the agreement. As a result, vertical agreements are normally considered to have less of a detrimental effect on competition and consumer welfare. Nonetheless, such agreements may fall foul of EU competition law should they interfere with the aims of the Union and interfere with the functioning of the single market, for example. Now let's look at the de minimis notion in EU competition law. When applying Article 101(1), the Commission applies a de minimis analysis whereby the restriction on competition resulting from the anti-competitive behaviour of the parties must be significant before the Commission will exercise its jurisdiction. If the anti-competitive effect of the agreement is minimal, the EU authorities will not bother to apply the prohibition. For example, in Volk and Verweyck, it was considered by the Court of Justice that a vertical distribution network that clearly had an anti-competitive structure nonetheless escaped the prohibition set out in Article 101(1), as it had an insignificant effect on competition in the market. In this case, the market share of the manufacturer Volk on the relevant market was 0.06%. More generally, the Commission has issued a non-binding notice as regards its application of the de minimis doctrine. The de minimis notice defines, by way of market share thresholds of the participating undertakings, agreements that are not considered to give rise to an appreciable restriction on competition under Article 101. The agreements coming within the notice are said to benefit from a safe harbour. The safe harbour created by this notice distinguishes between horizontal and vertical agreements. As regards agreements between competitors, horizontal agreements, where their aggregate market share does not exceed 10%, they will not be subject to the provisions of Article 101. For agreements between non-competitors, i.e. vertical agreements, the market share held by each of the parties should not exceed 15% in order to benefit from the notice. It should be underlined that the notice excludes from its benefit de minimis agreements between undertakings that contain hardcore or serious restrictions on competition. Now let's look at exemptions to the prohibition on restrictive agreements. The prohibition set out in Article 101 is not absolute, and along with the exemption granted for de minimis agreements, restrictive agreements may also be exempted pursuant to Article 101(3). The exception provided for in Article 101(3) comes into play where an agreement, despite its anti-competitive character, may nonetheless have an overall positive effect on the market. For example, a research and development agreement entered into between two car manufacturers to develop a new environmentally friendly car engine. Such an agreement will necessarily restrict competition between the undertakings in the field of research, but may lead to the development of a new product which will benefit consumers. The Commission has been empowered to issue block exemption regulations applicable to categories of agreement. A block exemption regulation is a legislative instrument adopted by the Commission exempting certain types of agreements from the Article 101 prohibition. Block exemption regulations exist in different areas. For example, the Technology Transfer Block Exemption Regulation or the Vertical Agreements Block Exemption Regulation. A typical block exemption regulation establishes a list of hardcore restrictions that an agreement should not have if it is to come within the terms of the regulation. Agreements coming within the terms of an applicable block exemption regulation are automatically exempted from the application of the Article 101 prohibition. Thus, a block exemption regulation provides undertakings with a guide that, if followed by them, will ensure that their specific agreement will not give rise to liability under EU competition law. In this way, block exemption regulations are said to create a safe harbour for business as regards the application of EU competition law. We hope you enjoyed this introduction to the control of restrictive agreements in European Union competition law.